Hey Jay, when we think about all the clients you deal with, would you share some of the issues or contractual situations that have arisen for your clients as it relates to name, image, and likeness?
As you become more and more influential, these types of war stories become more and more typical. So I need everyone to understand, just because you did a deal doesn't mean the next deal should be on the same terms or have the same sort of agreements. And so let me give you a great example. So we represent a social influencer, does very, very well for herself. But this was a contract that was presented to us for a relatively modest fee, and modest for her might be $10,000. I'm just giving that as an example, just to do a few Instagram posts, do a couple Facebook posts. But she didn't want to necessarily us to look at this too deeply, but she's learned from us that we really should look at every deal independently and make sure it fits what you're looking for. What we found in that, for this relatively modest deal, was that she was giving away her name, image, and likeness in all mediums forever, and even when this agreement was done. Now, she was shocked when we said, "Is this what you're agreeing to?" And in that case, I can tell you this: the other side didn't even necessarily mean for those terms to be included, but our job as your trusted advisors, or as I say, your performance coaches in the financial arena, realized that, hey, the literal language in this contract granted them far more access than she ever intended to give, and the other people never intended to take. But it is important to understand that between sophisticated parties, the language of a contract governs. So in this case, we prevented what could have been a monumental mistake for her. And that's the best example I can think of for everyone to understand why in this arena it's really, really important to get an expert, because actual contractual language governs in most of these situations.
And Jay, could you take it a step further? What would have happened to that social media influencer if she didn't get that protection?
Number one, let's say this went through and the other side decided to pick up on this and was hoping that she didn't have lawyers to protect her, or tax advisors, or any of the like. What would have happened is that she would have had to go to court later on, which, as you and I both know, gets very, very costly. It's very difficult to undo a situation saying, "I didn't ever intend this," than to actually put a couple dollars in at the beginning, do it right the first time. She would have been, all of her rights would have been given away to this company, and she would have had to go out and stop it somehow. But here's the risk you run. A court might just say, "No, this is what the contract says. This is what governs. Any of the conversations you had before that, sorry, too bad." So it could be disastrous, and we want to make sure, and I'm not here to try to scare you on that. Well, I'm only here to tell you that, measure twice, cut once. It's all about preparation. And I'll echo the words of our friends at Accelerate, when just Janine said, you are your own brand. You have to take charge. You have to have people on your side that are only looking out for your interests.
Hey, Janine, if we expound on that example of a social media influencer getting paid, what would it look like from a tax perspective, and where do 1099s fit in on this?
Yeah, a 1099 is, if anybody had a summer job, they know that they got a W-2, at the end of the year, and then they had to file their taxes. But a 1099 is kind of like a W-2, but it's what you're issued when you work for someone other than an employer, and they paid you money for that work. And so what that form does is actually, the employer, the company that you worked for or represented, fills out that form, they send a copy to you, and they send a copy to the IRS. And so the IRS knows that you've gotten paid. And it'll have your Social Security number on it, or if you create a company, federal identification number on it. And they'll be looking for your reporting at the end of the year. It typically depends on how much you earn. Jay just gave the example of $10,000, for the social influencer. If you earn $10,000, you're definitely getting a 1099 for it. But like I mentioned earlier, you may have, expenses that you can deduct towards that, so it might not be a full $10,000 in income that you end up paying taxes on at the end of the year, but it's going to be something. And I think, when you're self-employed, it's very important that you think about the fact that, that $10,000 that you're getting, a portion of it has to go for state and federal taxes and also Social Security and Medicare taxes. And when you're self-employed, you actually pay not only the employee portion of that, but also the employer portion of that. And so it's important to get some tax advice. And perhaps the simplest way to do this is, you owe that money to the federal government and the states as you're earning it throughout the course of the year. So if you do something in May, you should be paying that money in taxes, in that quarter. So by June 30th timeframe. If you don't, you can kind of get yourself in trouble towards the end of the year, and you might owe some penalties and interest for not paying it when you earn the money. So the simplest thing to do is when you receive your check for work, talk to your advisor, figure out how much you owe, and then send those payments in, and then, you're in better shape in terms of what you might have left for you.
Big shout out to Jay and Janine for being our guests on the show today, and thank you for tuning in. And we'll see you next time on NIL 360 EDU.